Let's see if it's working. Okay, so the camera wasn't working, but the screen is working. Okay. Where's my microphone? Good morning, everybody. Y'all give me a second. Give me a second, y'all. All right. Let's get into this. First, let me go and check the sound, make sure everything's good. Let's go back here, make sure everybody can hear me. All right. I know again, some of y'all probably gonna be at work, but I'm gonna go ahead and do this anyway, and I'll just upload it later for y'all to see it. If you have any questions, let me know. Before I begin, if you are watching, can y'all let me know how good can y'all hear me? Can y'all hear me? On a scale of 1 to 10, how good can you hear me before I start the live? How good can you hear me? I'm gonna come back and check this, but I want y'all to see this. Yeah. To everybody who loves music like me, and you've been paying attention, you know what's going on within the music industry. I'm gonna leave this up here for y'all to see. Not even debatable. It's just you can't even debate this. I don't even debate people when it comes to this. Shout out to Mickey Facts too. Hey Mickey, what the wiki whack doing? Me and I follow Mickey Facts on Facebook. He talks back to me sometimes. Mickey Facts and Lupe Fiasco are they friends. I'm hungry. All right, good. Sound check, good. 1, 2. All right, cool, cool. All right, so I'm gonna go ahead and start this. I'm doing this from scratch. The notice of appeal. This is really just to showcase. I'm not trying to brag anything like that, but this is really just to showcase my drafting skills. All right. I'm gonna do this from scratch. I'm gonna show y'all how you can go another route doing this if you want. I don't like to use their forms because sometimes I might like to say stuff or I don't like the way that their forms look. So we're gonna go to federal rule, appellate procedure, notice of appeal. There we go, right here. Um, they do have some forms on. Let me go to a PDF, because they do have the forms on here too. But I don't like to use these forms. I just don't like the way they look. So even though this says the Second Circuit, this is the uniform form that they use throughout um, all the U.S. district courts. So this is the form that you could use. I don't use this form. I never do. There's nothing wrong with using the form because attorneys do use it. But I don't like to use it. I like to draft most of the stuff that I do it from scratch. And I just don't like the way it looks. That's really the reason why I just don't like the way it looks. Um, so you can use this form if you want. There's nothing wrong with it. Now I'm gonna draft something. I'm gonna do this from scratch. So I'm going to pick a U.S. district court out and just draft this document for y'all to see. If y'all have any questions, anything like that, just let me know. All right, let's go back because I want y'all to read the rules. So if you're filing a notice of appeal or whatever, this is how you should do it. First, you got to go and read these rules right here, the Federal Rules of Appellate Procedure. So you're going to go here, and they're going to tell you the procedure that you need to do to appeal your case. So you're going to start with rule appeal as of route how taken. They're going to tell you how to start the case. I mean, how to start your appeal. So you would click on rule 3. And if I'm not mistaken, I want to say it's rule it's 3A1 right here. An appeal permitted by law as a right from a district court to a court of appeals may be taken only by filing a notice of appeal with the district clerk within the time allowed by rule 4. So you have to go and read rule 4 next. So what we're going to do, this is what we're going to do. I'm going to pick let's do Illinois. We'll do a case out of Illinois. We're going to use a U.S. District Court out of Illinois. So they have a northern district, and I think they have either 3 to 4 districts or something like that. Not really sure because I don't really litigate up there a lot. But we're gonna start it off just like this. Hold on, United States District Court 4. Cause I'm thinking of the I'm thinking we are already in the appellate court for the Northern District of Illinois, Eastern Division. All right, we'll highlight that, do it like that, bold it black so you can see it. I might make this a little longer. I don't like the way that look. Yeah, I don't have to do yours like this. This is just how I do mine. That's a little too long. I kind of don't like the way that looks. OBS Studio disconnected, reconnecting. Okay, so it reconnect. I don't know why I keep doing that. It does that from time to time. I'm gonna say we're gonna do John Doe. John Doe. Boom. All right. Let's go down. Whoops. What did I do? Okay. Right down. We're gonna do plaintiff. All right. We're gonna have the case number, cause number. Let's do 1, 2, 3, 4, 5, 6, 7, 8, 9. All right, we'll do it like that, just making stuff up. All right, whoops, forgot something. Just want y'all to see how all this stuff is simple, y'all. But I gotta do this just so y'all can see. Especially like if you don't know me, I get it, I understand. So I'm really doing this just to show you that I can do this stuff. And if you need help, then you need to come on to draft class. We're gonna say John Smith, whatever. Smith. All right. Defendant. All right. Do that. That. All right. So everything that I think that's a little too close. I don't like the way that looks. So we'll fix that. All right. How close is that? That's a little too close for me too. I want to space it just a little bit. And we'll leave it right there. All right. All right. And now we're gonna go to. I like to do mines like this. So we'll say plaintiff's first notice of appeal. The reason why you do this because you may have to appeal again. You know, your case, they may rule in your favor on the appellate court and the district court again. You know, they made the trial, which is the trial court. They may do something again that they shouldn't have did, and now you got to appeal it again or something like that. So let's see, plaintiffs first. Oh, we got 12. 12 looks like everything is 12. All right, and I would start it off like I'm gonna put a footnote in here later. I would start it off like notice is hereby given let me turn that bold off. Was it John Doe hereinafter plaintiff. I hope y'all can. Let me check because I need to make sure that this is big enough that y'all can see it, and let me make sure that y'all can actually see the screen. Let me move that right quick. I like that. I might need to move this too. I'm so picky, y'all, but this is how I do my work. I'm extremely picky. We'll leave it like that. What was that? Yeah, we'll leave it like that. I know y'all like he's so damn picky. Okay. Pursuant. Okay, so pursuant to a rule. What rule? Let me go back and check the chat just to make sure y'all are seeing everything. All right, cool. All right, how many litigators? All right, JL10. Okay, cool. Okay. Focus says, can I speak up? What about now? Is the volume good now? Is the volume good now, Focus? Let me read some of these comments. And are y'all able to still see the screen? Because I'm just doing a little practice. I mean, just showing y'all how I do my notices of appeals. I don't do them like they do theirs. I'm way out of time. See, I didn't know what they were doing until more recently. They did a substituted service, and then is extremely difficult to navigate. Oh, and that is extremely difficult to navigate. Okay, it says the voice is low. I, I what about now? I guess I got to hold the microphone up to my mouth. Is that better? It's still low. All right, hold on. Let me try something out. Hold on. Or okay, is it just low for you, Focus, or is it low for everybody? Because earlier, some people said that they didn't have any problem with it. So if the volume is, it may just be your computer then, Focus. Okay, so everybody else can. Well, a few other people can hear me. Let me check my microphone. Give me a second. All right, what about now? Great. All right, cool. Okay. All right, we'll try it again. Where is, what was that? Okay, I was drafting this notice of appeal. All right, rule. Okay, that rule was all right. Thank you, folks. All right, that rule tells you how to do it. So we're gonna go pursuant to Rule 3A1. So we're gonna say. Now I want y'all to notice that the notice of appeal, like the form that I just showed you prior to me starting this, it did not have any of this stuff in it in regards to the way that I'm about to do it. But this is just how I prefer to do mine. All right. So was it rule? I think it was rule A 331, and I bold mine like this. All right. I bold my stuff like that. That's how I do it. Then was it of the federal rules of appellate procedure. There's two rules though. I forgot all about that. Put a little indentation in there or whatever. That's only one of the rules. All right, so we got to do two of them because I think there's another one too. And I think it's rule 4. Rule 4. Let me go and see. I know it's rule 3 and it's rule 4. So let's go to rule 4 and see what they say. All right, rule 4A1. All right. You got 30 days to file your notice of appeal, unless you like unless you the government or something like that. I think they got 60 days. And 4C, let's see what's 4C pertaining to. I think 4C relates to people who are in prison. Let me see. Okay, appeal by an inmate confined in an institution. If the institution has a system designated for legal mail and an inmate confined there must use that system to receive benefit of Rule 4C1. If an inmate files a notice of appeal in either civil or criminal case, the notice is timely if it is deposited into the institution's internal mail system on or before the last day of file. Okay, so that doesn't apply here. So what applies here is Rule 4A1A. All right. Rule 4A1A. If I'm not mistaken. See how very detailed I am with this stuff? Y'all don't have to do it like this, but this is how I do mine. That's the wrong one. Of the Federal Rules of Appellate Procedure. All right. And you want to say something like, what are you appealing? So you would say appeals, doc. We're gonna say doc, 50. We'll say doc 50. Doc 50. Entered. You gotta let them know when it was entered. I don't think that's it really matters, but if I'm not mistaken, I think they kind of want you to put a date in it just to make it a little easier for them to determine if you have timely filed your notice of appeal, if that makes sense. Entered, and I highlight this too. I normally bold this and highlight this too, but I'm not gonna do it this time. So we'll say it was entered on what is it? This is April. We'll say it was entered April the 6th. April 6th, 2024. All right. I bold this. I make all this capital. And then I might shrink it, probably maybe a 10, something like that, because it's already capitalized. And then you got to put the title of the court that you're appealing to. So-called court, anyway. It's the United States Court of Appeals is an administrative agency, anyway. I know you don't think it is, but it is. It's an administrative court. It was created by Congress. So their jurisdiction is extremely limited as well. United States Court of Appeals for the, what is it? They are Illinois. I think Illinois is the 7th Circuit, but let me see. I got to double check. So we're going to see. Seventh Circuit Court of Appeals. I think they are Illinois. I think it's Illinois. Yeah, it's Illinois. So it's Illinois, Indiana, and Wisconsin. All right. So we good. We in the right one. All right. For the Seventh Circuit. Boom, right there. And then I bold this as well. Hold on. Bold that as well. I go down. I want to, well, why is it doing that? I put me a signature line down here. You probably can just, hold on, let me show you. Where's that line at? Yeah, I'm gonna put an underline, make sure it's underlined, and we're gonna say John. I don't even think you gotta sign it, to be honest with you. Yeah, we'll leave it. I guess we'll leave it alone. I might do something like plaintiff, pro se. I bold this. I actually bold all this. Do it like that. Of course, you got to put your address and stuff in it too. So don't forget to include your address, email address. Let me do 123. I'm gonna do Earth Street. Earth Street. I'm gonna say Illinois or whatever. I'm just making some up, y'all. Illinois. We'll say 123. Yeah, we'll say 123 Street. Earth, Illinois. Yeah, we'll do it like that. Earth, Illinois. Yeah, you put your email address in. 123 at gmail.com. This don't supposed to be like that. Let me turn that off. There we go. And I think we need a certificate of service on here, if I'm not mistaken. I'm gonna put my footnote in here. Yeah, let me go and put my footnote in here too. I'm gonna go to case text. All right. So let's say Federal Rule of Appellate Procedure, 30 days appeal. We'll do something like that. And we are in 30 days. Oh, that's too short. Okay, we'll say timely appeal then, since they won't give me nothing to work with. All right, there we go right there. Now we in Illinois. We're gonna go to the 7th Circuit. We're gonna find some cases over there. All right, let's go. Appears to counsel for the appellant, 30 days time notice. This leaves plaintiff 30 days prescribes the time for 30 days to introduce. All right, we can use that. Might use that one right there. And I would, well, let me just do this. Copy this. I'm gonna go and get it from this case. Y'all don't have to do all this. Their notices are way simpler than mine. I'm just very detailed with my work. Right there. So we got the notice of appeal. The prescribed time referred to is the 30 days after entry of judgment, blah, blah, blah. And no extension, we seem to exceed 30 days. Let me try another case. I don't like the way this one look. I know y'all like he's so picky. But this is how I do mine. This is how you let them know. Wow, he did this from scratch. He ain't no joke. He's something. We gotta watch him. We gotta watch him. I might just type it in here. Oh, palette. Excuse me, y'all. All right, we're getting somewhere. Let's go and make it more. That's not it. This might work right here. I don't know how I did it the last time. Rule of procedure. Let's go here then. Maybe that'll work. That one ain't gonna work. They ain't gonna get it to me. All right. What's that? Yeah. I guess I'm gonna have to use that other case then, because it's taking too long. I ain't got time for that. I'm just trying to show y'all how it's supposed to look. 30 days to appeal the district court. Okay, well, we can use that one. That's cool right there. I like that. All right. What we got? We begin, and we must, with our jurisdiction, and specifically, blah, 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 the timely filings of a notice of appeal. Yeah, I need to tell y'all this, by the way. I'm glad they showing this right here. So right now, when you appeal your case, generally what they're going to do is they're going to make sure that they have jurisdiction over your appeal by making sure that you have at least filed it within the allowable time for an appeal, or and that you have filed a timely notice of appeal, because the notice of appeal is a jurisdictional prerequisite, and what that means is, unless this notice of appeal is filed, they cannot exercise appellate jurisdiction over your case. So you got to file this notice of appeal. You got to do it. Now there are some cases in which a notice of appeal will be told, meaning the time would just be stayed pending a disposition of a motion, maybe like a motion to reconsider in the court that just ruled against you, something like that. Let's see. Let's go here. All right, where we going? See right here where it says on the U.S. 28, what is it, 2107, and the Federal Rules of Civil Procedure, said he had 30 days to appeal. Let's see what that says. Except as otherwise provided, no appeal shall bring a judgment, order, or decree in suit from the civil action, blah, 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 unless a notice of appeal is filed within 30 days. It's a statute. There we go. So we can use that. We'll use both of these. We'll copy this. I'm going to copy that. I'm going to put this in my footnote. Even though y'all don't have to do it like this. This is just how I do mine. Go to references, insert footnote, boom. And I might change this and say, pursuant to blah, blah, blah. Let me see. We'll say plaintiff has 30 days to appeal. Something like that. You don't really have to do that. I would change the font on this. The Times New Roman. I would also make this smaller, probably about maybe an 11. Make all this black. We're not gonna do that. All right. Make that black. I would take out this hyperlink. Oh, it looked like it's already taken. Is it already taken out? Yeah, it is. It's already taken out. And I would say see space bar that. Then I will go back to the case. I know y'all like, man, why is he going through all this? I will copy the case citation and I will paste the case citation. Post it in now. Times New Roman. What is this? It's a we'll do 11 on that as well. And I always bold my cases. Something like that. I don't like that. That's a little off. Let's change that font too. All right, that's cool right there. I like that. I like that. All right, looking good. Looking good. All right. Now we got to do you got to do a certificate of service too. So the certificate of service is just stating that you're certifying that you have complied with service of process in order for the appellate court to exercise appellate jurisdiction over the defendant. You got to give them notice. So certificate of service. Probably spelled certificate wrong. Let me see. Yeah, I did spell it wrong. Why y'all ain't tell me I spelled it wrong? Certificate. Probably still spelled it wrong. Oh well. Certificate of service. And we'll say something like plaintiff certifies that on this, what is this? We said we're gonna use today's date. So on this, what is this? 23rd of, 23rd day of April 2024. Of course, y'all know I gotta bold that. Let me go back and check the chat. What is it bold? Okay, you can either say I electronically or I via, we're gonna say via certified. I want to say via U.S. certified mail have let me see how I'm gonna word. Let me go and check the chat right quick just to make sure we still good. JL, I hear you. Okay, what peace God. What do you see? What authority says it'll be null and void? What do you mean, JL? What do you mean? American Sign Language is not part of the English language, and when you have more than one language, the instrument is null and void. I hear you. Okay. This is how they trick us grammatically, fuckery. Okay. They stopped teaching Latin in school around 1960s, so most people have no idea how to spell or read. It's all another language. I agree. That's why you need a law dictionary. You do not need to assume you know what they talking about. Just don't do that. I'll be right back, y'all. I always put a notice to defendants of 30 days are allowed to file an answer as a rebuttal of defense. That might be a good strategy. All right, let me go back to the document. I'm almost finished with it. That's just how simple it is. I have served each attorney of record a copy of, let's say, this notice. This notice in a manner, I want to say in the manner required, I'm going to say in the manner required by due process, something like that. I don't see nothing wrong with that. I think that's good. Mm, it probably took me maybe 30 minutes to do that. All right, that's cool right there. All right, so that's pretty much how you do a notice of appeal on the federal level. It may require you to do it different on the state level. All right. Excuse me. I don't know. I'm eating right now, y'all. So I do apologize for that. But they may require you to do it different on the state level. I don't know. It just depends. But if you want to be more detailed than this, you can. But this is pretty much it. I mean, that's it. So you can do yours their way if you want. There's nothing wrong with that. And or you can do it the way that I did. Gary says, and get your filing notarized. You can if you want to. I don't, but you can if you want to. What would be the what reason would you be getting it notarized for? I guess other than to prove that you actually did it and served them or something like that, or that you actually attempted to perfect service or process on them. I guess that would be it. Would that be it, or is there another reason? Let's go. All right. Hopefully this helped y'all. I'm not gonna be on here long, y'all, but I just wanted to. I had to come on here and just show people that this is what I do. This is me. This is what I do. I know how to draft paperwork. So if you need help with drafting, I don't care what it is. I'm pretty sure that I can draft it. But if you need help, you need to go and register for draft class. Let me go over to the page and I'll read it over again to you. You need to register for draft class. It'll be next month on I think the 20th. Let me go and see. Right here. I'll read the instructions again. If you want to attend draft class next month, send me a $50 deposit via Cash App, Zelle, or PayPal, plus the transaction fee. Then email me once the deposit is made, and I will email you a registration link. The deadline for full payment is May the 18th, 2024 at 11:59 p.m. Central Standard Time. I've been getting questions about like what types of documents are we going to be drafting. I don't want to confuse anybody or overwhelm anybody or intimidate anybody. So in my own personal opinion, I would like to start off with something simple like a motion to dismiss. And we can go from there. But on the first day of class, I'm going to make sure that everybody has the form of it down, how to draft the form of it, because all of it is the same. You can literally, excuse me, You can literally just copy and paste this right here. Let me show you. In your motion or whatever, you can literally copy and paste this. Let's go down and we're gonna go to another page and I'll show you what I'm talking about. Where's it at? In a second. All right, you can copy, paste this here, put that in the center. Just change this title right here. Plaintiffs first, I'm gonna say motion to dismiss. Motion to dismiss. See how simple this stuff is? But you gotta make sure that you're following the rules. You gotta make sure you're following the rules, or they will sanction you. They'll give you some time. You know, they might give you maybe 1 or 2 trials or something like that. But they will sanction you if you do not follow these rules. Meaning probably dismiss your case. Plaintiff's first motion to dismiss, whatever you want to call it. My cash app. I'm gonna put the cash app on the screen too. I'm gonna make it a little bigger. Probably about right here. So you can send payment here. Just make this is my cash tag. All right, that's the cash app. Let me just capitalize all that. That's the cash app. My PayPal is, what is it? Smart TV. Right there. Make sure you cover the transaction cost. I'm not sure how much it is. I don't. It's not expensive, but just make sure you cover it. I'm not liable for that. That's the email address for PayPal. And if you want to do Zelle, you have to send me a message. Send me an email to this address right here, or whatever, and we can talk like that about Zelle because Zelle works a little different. But there's no transaction fee in Zelle. Just to let y'all know. That's why I prefer y'all to just do Zelle if you don't mind. But it's all easy, y'all. Let's go over a little bit more of the details of the class. All right. So the class is gonna be a 6-day, 18-hour class. All right. So it's gonna be Monday, Wednesday, and Friday 1 week, and then Monday, Wednesday, and Friday another week, and it's gonna start at 7 p.m. It's gonna be a 3-hour class each class. So you can ask all the questions you want, because I don't know what type of questions y'all are gonna ask. I don't know. I had 22 people here said that they need help drafting motions. I have videos on here too teaching you how to draft motions, but if these videos are just not helping and you don't understand how to put your arguments in the motion, then you need to come to class. That's what you need to do, and it's $200, all right? But if you can't afford a $50 down payment and I guess $25 a week or $50 a week until you pay it off, I don't know what to tell you because that's cheap. That's cheap. But I do understand, stuff is expensive. Everything's going up. That's why to be honest with you, I don't think this is expensive. That's how I made it this cheap. And if I need to do another class with the same thing for 10 other students or whatever, then so be it. All right, but I expect everybody who registered for this class to graduate. I don't think you're gonna need me again, to be honest with you, because if you can draft, once you learn how to draft motions, you should learn how to draft other stuff too, because it's all the same thing. Some of them just a little longer than the other ones, but it's all the same thing. Now let me check the chat, see if we got any questions, then I'll get out of here. and get your filing notarized because it is, yes. Plus, it's an affidavit. Well, yeah, it is. It does become an affidavit, but I wouldn't. I mean, I wouldn't notarize a. This is just me personally speaking, Gary. No offense, but I wouldn't. I wouldn't notarize a notice of appeal. I wouldn't even go through that. Now your complaint, you can get your complaint notarized, but you need to be careful when you do that to make sure you're not using anything that you didn't say anything in that complaint that can be used against you, because all pleadings are taken against the pleader, meaning anything you say can and will be used against you. But if you get your complaint did and you do it right and you go and get it notarized, it's an affidavit. And they consider those as judicial admissions, especially if they don't dispute them with another affidavit. I think that's a good strategy too. Let's see. All right. Well, look. If don't nobody have any more questions, I'm gonna go ahead and get off here. Um, oh, it's David. Okay. It's audio. I just emailed you back too, David. By the way, I just saw your email. It's audio. It's all audio. I think I emailed it probably like 6 times just to hope that you get it. I don't know how many times. Did you get the PDF file in there too, David? Because there were a lot of files in it, so I want to make sure that you got everything. The PDF file I think is maybe like 500 and some pages, almost 600 pages. I want to make sure that you got everything. All right, I'll give you some time to let you check. I'm gonna get off here in probably like 5 minutes, y'all. I'm not gonna stay on here long. Oh boy, I was reading. I found this other case. These some really good cases on here, man. These are some really good cases. These old cases, they talking about child support like in the 1800s. This case that I'm reading right here is about 8 pages. Real interesting. All right. We got 10 minutes. I know I'm quiet. Y'all like, what is he doing? But I'm not gonna be long. I just want to show y'all how to do this stuff from scratch. Not hard. Can you post a link for that case about child support? Is it the case from last night? I think it was Ramsey versus Ramsey. Is that the case you're talking about? If so, yeah, I can. I got to make sure that's the case that you're talking about, though. Because if that's the case you're talking about, then this is the case right here. They actually have this entire volume. I think this is volume 121. This is the entire volume, the entire Supreme Court volume, well, one of the entire volumes in Illinois. They actually have it in a PDF file. Let me go back and see. Okay. If you want to include evidence in your complaint, you can, but I wouldn't. I would just I would just wait until we go through discovery and all that stuff because it's gonna be treated as, it's not even, the evidence is not even properly admitted yet. It's hearsay until you get somebody to come in and that can authenticate it and lay a proper foundation for the evidence to be properly admitted. So I wouldn't file anything with it. You can if you want to, and they may try to use it against you, but then now you got to file objections and stuff like that. What is it? Do you include evidence in it? And yes. All right. I'm gonna pull it up for you, and I'm gonna show you. I'm gonna just copy and paste it and put it in the chat. This is the entire volume in a PDF format. All right. So if you click that link that I just posted in the chat, it's gonna give you the entire volume where that case is, and that case that you're looking for starts on page 215. Let me double check. I think it's 215. Yeah, it's 215 right there. From 1889. I think I'm gonna double check. Let me check because I think that they actually have some older cases too. And I'm trying to see because I want to go back and see how old these cases are. So here's one, husband and husband right here. So husband and husband. This is an earlier volume, so it has to be older than the previous case. Let me see how old this case is. What's that? Oklahoma? Oh, that's an Oklahoma case. Okay, that's wrong. Okay. Why does it say Indian? Why does it? I think that's wrong. I think they pulling up the wrong case because this clearly says Oklahoma, but that doesn't say Oklahoma in there. That says Indiana. Let me go and see. But they do make mistakes on here, so let me go and see. I think this is supposed to be an Indiana. Wait a minute. Husband and husband, blah blah blah. Ramsey. Let me go and look this case up. First, let me save this. I'm gonna save that because I do want that. All right. Now let me go back, and that was volume 67, I think. Volume 67. They might got this one on here too. Let me see. Oh, so they got the whole volume of this one on here too. What types of cases are these? Cases argued and determined in the Supreme Court of Judicature. What does that mean? Of the state of Illinois. Containing cases decided 89 reported in Indianapolis. Let me, what was it? I think it was 67. 67,583. Let me see what that is. Did I lose the case? I don't know where it's at. I'm trying to find. I don't know where it's at. Did I lose it or something? Is this it? I don't know where it's at. I must have lost it. 67, 583. So we're gonna go to 583 and see what we get. That ain't it. That's the wrong page number. 583. So here it is too. So what are they talking about then? 17. This is 1879. So this case is earlier, before the one I just cited, which was from 1889. So the 1889 case got that case from this case. There it is, right there. They talking about it right there at the top. Award of custody of the child to the mother deprives the father of the right to its services and frees him from liability of its maintenance by mother. Res judicata. There it is right there. Here it is right there in another volume and in an earlier case. So what this means, in my opinion, is that there are cases that have probably been decided that are earlier than 1879. They've been knew about this, y'all. I'm telling you, they knew about this stuff. Sorry about that. The audio low. Let me go back. I'm gonna unplug it and put it back in. Give me a second. Let me unhook the microphone. I'm gonna hook it back up. All right. Hopefully that's better. Um, let's see. Thank you, my understanding. Thank you to my understanding. When you include evidence or exhibits, you substantiate you substantiate your claim because they are big on saying felon. You right now. You're right about that, Dave. You're right. But right now, you don't have to prove anything to prove your claim right now. So when you first start in the case, you're just making allegations. That's all you're doing. All you're doing is just making allegations. Just making allegations. Has what case been overturned, Gary? In the case that I just read in Indiana? Because if you're asking me if has that case been overturned, I'm gonna say no because that's a principle. That's equity. That's a principle. That's equity. I'm gonna read it again. I'm gonna let me see. I'm gonna see how long the case is. If the case ain't too long, I'll read the case. Husband and the husband. So it's 55. Okay, I'll read the case, Gary, because I think it looks like it's about 4 or 5 pages long. Let me make sure. It ain't even that long. All right, I'll read the case. It's about 4 pages long. So I'll read the case. If you're talking about the husband versus husband case, is that the case you're talking about, Gary? Let me go back to the chat and see. Um, which ebook, David? In regards to the to evidence, if you're talking about in regarding the evidence, no, my ebook does not. That I would have to charge more for the ebook, and it would take me longer to complete. But the seminar that you're about to listen to, he does talk about that. He talks about that. You want to familiarize yourself with the rules of evidence because that determines the admissibility or the inadmissibility of evidence. And any type of evidence, even if it's inadmissible, will be admitted against you if you don't object to it. That's how they tried to do in my case, but we raised all of these objections, you know, and they never responded to any of my objections, none of them. They never said the objections were meritless or none of that. They just ignored everything because they don't want to tell me I'm right. Essentially, I don't file meritless objections. I I don't file meritless lawsuits. I'm not. If you contact me for some assistance about your case and we talk about it and you want me to take your case and I'm like, I don't think you can win this case. I'm gonna tell you something like that. I don't think you can win this case, and I'm gonna tell you why. And then I'm gonna say, in my opinion, I think you're just wasting your money. I wouldn't do that if I were you. I wouldn't do that if I were you. That's how I am. I'm not gonna be no attorney and just take your case, file a patently frivolous, meritless argument, and act surprised when it gets dismissed. I'm not gonna do that. I'm not doing that because they will do that. They will do that. All right, I'm gonna read the case right now, Gary. I'm gonna read it, and what I'm gonna do, since if y'all got questions, I'll stay a little longer. So I'm gonna cause I'm curious about this stuff too. I'm trying to see how old, when was this principle first established? That's what I'm trying to figure out, and I want to see what's the oldest case, how far it goes back. It just depends, David. It really depends. Um, and it's really based on how many defendants that you're trying to sue because we can negotiate like an upfront um hourly fee or whatever, and then after that um I get a percentage of maybe a settlement or a judgment order, something like that. We can do it. That's how I do it. You know what I'm saying? Let me go ahead and read this case. I'll be right back. I'm gonna come back and check the chat from time to time. Y'all hit that like button if you don't mind. Also, I gotta throw this out there. If you haven't, please go ahead and join my Juror Members membership. It is 99 cents. I would really appreciate that if you did. All right, let me go and read this case, Gary. Where is it? You right here. All right. So let's see. MP uh Pierce, or whatever you say, for the appellant, W.E. Edis, W.P. Edison for appellee. Okay. This was an action by the appellant against the appellee to recover an alleged indebtedness of $2,000 for the care, maintenance, and support of Adelia, husband, and infant daughter of defendant. Okay, you know what? Let me stop right there. Since they're saying this, I gotta read this other case. This other case that I'm about to read is like 3 or 4 pages long. It's from another jurisdiction, but it's a principle in that case in regarding to debt for child support, and I feel like I gotta read that case. So give me a second, y'all. I'm sorry. I know y'all were ready for it, but give me a second. Cause I just read this case before I went live. It was two of them. I think it's this one right here. It's one in Illinois and it's one in Nebraska. The one in Nebraska is shorter, so I'm gonna read that one. See, this one is 3 pages. All right. This is the Nebraska Supreme Court. Let me give y'all the case citation. Um, Look like it's volume 193. I mean, page 193. What volume is it? Volume 13, right here. Well, it just went away. It's volume 13, page 193. All right, this is an application for a writ of habeas corpus. The petitioner alleges that at March 1879, term of District Court of Richardson County, he was adjudged to be the reputed father of a bastard child, theretofore born of one Nancy Perkins, an unmarried woman, and he was adjudged to pay the sum of $10.85 a month for the maintenance of the child until it should be 10 years of age, and also the cost of prosecution, and was required to execute a bond to said county in the sum of $1,000 with approved security for the performance of said judgment. And in case of default, he was to be committed to jail of said county. It appears that the petitioner has failed to comply with the judgment of the court and has been committed to prison from which he now seeks to be discharged on habeas corpus. So he's saying they unlawfully imprison him. We're going to see what they say about this. The principal ground upon which a discharge is sought is that the act providing for imprisonment is such in such cases is conflict with the Constitution. So he's making the argument that he's being imprisoned for a debt due to this child support thing. Article 20 of Article 1 of the Constitution provides that, I'm assuming this is the Nebraska Constitution, no person shall be imprisoned for a debt in any civil action on, what is that? Menze, or I don't even know how you pronounce that. Minzny or whatever, or a final process until, unless in cases of fraud, is a proceeding in bastardy a civil action. So that's the question. In Cottrell versus the state, it is said the proceeding is in the nature of a civil action to enforce the performance of a civil and moral obligation. So that seems like equity to me. I don't know, but it seems like equity. Not legal obligation, moral obligation, or not legal right, but a moral obligation. I need to go and read that case. In Mercer versus Stewart, Ohio State, it is said, this is not a suit to recover a sum of money owing from the defendant to the complaining party. The liability sought to be enforced is not founded on contract, express or implied. So I'm assuming you can't be sent to jail on something that has to do with an express or implied contract debt, that type of debt. But it originates in the wrongful act of the defendant against the consequences of which the statute is designed to protect the public, not you. When they say public, they talking about the government. In Hoopman versus Schreiner, 15 Illinois, is that 15 ed 43? I think that's, I don't know, is that Indiana, or I don't know what that is. I have to figure that out when I get some time. It was held that the provisions of the code for the discharge of persons in prison for debt had no application to the case of a defendant imprisoned by order of a court under the Bastardy Act. In Holmes versus the state, G.G. Green, blah, 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 it was held that the portion of the act was authorized. It was held that the portion of the act which authorized imprisonment was unconstitutional and void. This case evidently was decided under a misapprehension of the law, and we have been unable to find any case where it is cited with approval. The proceeding, which is in the nature of a civil action, is properly a police regulation requiring the putative father to furnish maintenance for the support of his child and to indemnify the public against liability for its support. The sum charged against the petitioner is not a debt in the sense in which the word is used in the Constitution. The statute is not in conflict with the Constitution, and whereas in this case there appears to be no doubt of the truth of the charge against the petitioner, the law should be enforced to the full extent the writ denied. So they didn't really go into detail. So I'm assuming he didn't. I don't think he raised any equitable claims in regards to him being liable for this debt. So let's go back to this case. So even though it is a debt, they're saying it's not a debt in that sense. The one that's derived from a contract, expressed or implied. Where we at? All right, let's get back here. I'm sorry about that. This was an action by the appellant against the appellee to recover an alleged indebtedness of $2,000 for the care, maintenance, and support of Adelia husband and infant daughter of the defendant from the 5th day of March 1863 to the 1st of October 1877 at the special instance and request of the defendant. The defendant answered that he was the father of the child mentioned, who was the issue of a marriage between himself and the plaintiff, that on the 4th day of March, of the March term of the Court of the Common Pleas of the County of Posey, aforesaid, the plaintiff herein obtained in that court a decree of divorce against the defendant herein, and for the sum of $1,500 as alimony, and for the custody of said child, and that during all the time for which the plaintiff sues for the support of said Adelia, the plaintiff, by order of said court, as aforesaid, against the will and consent of the defendant, and not at his instance and request, assumed and took upon herself to the care, custody, and support of said child. Man, this is a good case. This is a good case. Let me go back up because I want to read that again. Let me see. Where does it start at? That on the 4th day of March, that on the 4th day of the March term of the Court of Common Pleas of the County of Posey, aforesaid, the plaintiff herein obtained in that court a decree of divorce against the defendant herein, and for the sum of $1,500 as alimony, and for the custody of said child, and that during all the time for which the plaintiff sues for the support of said Adelia, the plaintiff, by order of said court, as aforesaid, against the will and consent of the defendant, and not at his instance and request. Okay, so they're saying that it seems like they're saying that he didn't request this to happen. He's not the cause of it. That's what it seems like to me. Assumed and took upon herself the care, custody, and support of said Adelia, wherefore, etc. The plaintiff demurred to the answer for want of sufficient facts, but the demur was overruled and exception taken. So she's going to take these issues up on appeal. Thereupon, the plaintiff declining to reply, judgment was rendered for the defendant. So they ruled in the favor of the father. The question presented is whether the court erred in holding the answer good. Does the law imply an obligation on part of the father to pay his former wife for her support and maintenance of the minor child or children of the marriage, where she has obtained a divorce decree from him and has in the decree been awarded the custody of such child or children? The question must, we think, be answered in the negative. They mean the question, they mean the answer to the question is no. That's what they're saying. The right of the parent to the services of the child and the obligation of maintenance devolving upon the parent have been said to be reciprocal rights and obligations. This is an older case right here. See as remotely bearing upon this point the case of Kerwin versus Wright. This is an Indiana case, 59. We're going to read that case next. I'm going to look at that case. In 2 Bishop Marriage and Divorce section 557, it is said, the true legal principle applicable to cases of this kind seems to be that the right to the services of the children and the obligation to maintain them go together. And if the assignment of the custody to the wife extends to depriving the father of his claim to their services, then he cannot be compelled to maintain them otherwise than in pursuance of some statutory regulation. This is interesting. There can be no doubt but that the awarding of the custody of the children to the plaintiff in the decree of the divorce deprived the defendant of his right to her services. That's where Ramsey get this case from, because they say the same thing in that Ramsey case. It could not command her services while plaintiff was entitled to her custody. Man, that's a good argument. They're saying that the father, he could not command her services. How could he command her services if he's not in custody of her? That's what they're saying. They're saying these rights are reciprocal. They're saying his duties are conditioned upon the fact that her he I can't even get it out. I can't even get the words out of my mouth. I'm trying to talk so fast. They're saying that these rights are reciprocal. They're dependent on each other. Put it like that. They're not independent of each other. And if the principle above announced to be correct, neither the former wife nor anyone else could maintain an action against the father. Wow. For the support and maintenance of the child, while he was thus deprived of her custody and services and any obligation arising out of duty. But we desire to pass only upon the point involved in the case before us, and we express no opinion as to the right of a third person to maintain such action. The statute in force at the time the divorce in question was granted provided that the court, in decreeing a divorce, shall make provision for the guardianship, custody, and support and education of the minor children of the marriage. The same provision is contained in the present statute. Excuse me, y'all. It seems to us to have been clearly intended that the rights of the parties in a proceeding for a divorce as to the custody and support of the minor children of the marriage should be settled and determined in that proceeding and not left open to further independent litigation. It is not, it cannot be even plausibly contended that if the plaintiff had in the divorce suit been awarded a definite sum of the support of the child, she could afterward have maintained an independent action for more. What is it? It cannot be even plausibly contended. So they're saying they can't even argue that if the plaintiff had in the divorce suit been awarded, a definite sum for the support of the child, she would afterward had maintained an independent action for more. Oh wow, that's crazy. Let me go and check the chat. Let me check this chat. Have you filed a Rule 52 yet? What's a Rule 52, Jr.? Uh, Post the link. Post. You want to read this case, David? You said post a link to this case. All debt is just accounting. There is no money. I agree with that. Sorry, but fact. I agree with that. I agree with that. They all negotiable instruments. I agree with that. Awarded custody. You are their biological creators, not a pair that rents. I agree with that too. Let me see what JR bet. Please post a link. Let me see what he's talking about. He's saying post a link, but a link to what? Oh, the case that I'm reading right now. Okay. All right, give me a second. Let me pull the case back up again. All right. The case that I'm reading right now, this is the entire volume in Indiana. I'm going to read that other case that they mentioned in here too, which is this Curran versus Wright case, because they're saying that they're similar. And the fact that this is volume 59 tells me that this case, this principle is older than 1879. It's on page 583 in this book. Let me give you the volume. It's volume 67, and it's on page 583 in this book. Bro said, "Give me the case. Give me the citation. I don't know." I feel you on that, man. I feel you on that. If y'all are just tuning in, I already did the how to draft a notice of appeal. I already did it. probably about an hour ago or a little over an hour ago. So you have to go back and watch the video. But I'm reading this case right now. I'm gonna go back over it and finish reading it, and then I'm gonna go to that other case too. This is how you need to do your y'all, man. Look, you got to read these old cases, fam. This is where your principles were established at. This is how these people are infringing upon your fundamental rights. Because how you gonna argue that they're infringing upon your fundamental rights if you don't know your rights? This is why when you go back and read the old cases about the right to travel, I'm gonna pull up. When I finish this video, when I finish reading this case, I'm gonna look at two more cases, and I'm gonna go to the one where they talking about a driver in that case. I think it's an Alabama case. I'm not really sure, but I think it's an Alabama case. But the case is funny because you're gonna see how they playing with these words. This is why you got to go and read these old cases. These attorneys, they not as smart as you think they are, man. They got all this stuff from a long time ago, from the people when people they didn't have computers, they didn't have cell phones, they didn't have the internet. All they had was libraries and books, and they had to fashion these remedies based on principles. All of these remedies that for example, the when they saying the father is relieved from the duty to support the child, that is a principle. That remedy is based on a principle. That principle is equity. How do I know that? Because when they use the word fault, that lets me know right there that they talking about equity. All right, let me get back to this case. What was it? I think it was this one. Yeah, we were down a little bit more. We're down about right here. I'm gonna read that part again. I gotta read this part again. It cannot even be plausibly contended that if the plaintiff had in the divorce suit been awarded a definite sum for the support of the child, she could afterward had maintained an independent action for more. So he's saying that that if she was awarded a definite sum of money in a previous divorce decree, then she can't come back and ask for more. If I'm not mistaken, I think that's what it's saying. If I'm not mistaken, so she can't file a motion for a modification of child support or alimony or something like that. I'm just gonna say child support, and that's what they're talking about. But it was not necessarily obligatory upon the court to make any allowance to the plaintiff for the maintenance. Oh my God. Y'all, did y'all see that? But it was not necessarily obligatory upon the court to make any allowance to the plaintiff for the maintenance of the child, although her custody was awarded to the plaintiff. The matter rested in the discretion of the court granting the decree and was to be determined from the circumstances and the situations of the parties. So here's another case right here, Indiana, that they're citing in support of what they're saying right here. The court may well have thought that the allowance to the plaintiff of the sum of $1,500 by way of alimony rendered it unnecessary to make her a further rendered it unnecessary to make her a further allowance for the support of that is crazy. But if not allowance but if no allowance had been made for the alimony, the point here involved would have rested upon the same foundation. The action for divorce was one in which the plaintiff might, if her case warranted it, and should have obtained a provision from the support of the child, but having taken her decree for divorce and the custody of the child without any provision for its support, she took upon herself the burden of its support without such provision and cannot now maintain an action for such support. She is stopped by the record to claim now that she should have secured she is stopped by the record to claim now what she should have secured if entitled to it in the action for the divorce. If the court in the action for divorce erroneously refused to make her an allowance to be paid by her husband, the father of the child, for its support and maintenance, she had her remedy. Let me read that again. If the court in the action for divorce erroneously refused to make her an allowance to be paid by her husband, the father of the child, for its support and maintenance, she had her remedy. We are of the opinion that the answer was good and the demurs properly overruled. Says she is a star. They talking about equity. That's what they talking about. Let me go and read this other case. I wasn't even supposed to be on here this long. Y'all done tricked me. What is that? Let me save this case too. Illinois Supreme Court. All right. I ain't gotta spell it right. I don't care about that. All right. That was that. That was volume 59, page 369. So volume 59. Let's go to volume 59. Where is it at? Right here. I think it was page 369. Let me see if we can get it in PDF format. Okay, they got this whole volume on here too. All right, so it's page, what was it? 369, I think. Okay. There it is right there. Let's see how long this case is. Um, let's see. If it's too long, I ain't gonna even read it. Okay, it ain't that long. I'll read it because it ain't that long. It's just like 6 pages, maybe. Let me go back and check the chat. Master and servant. Look at this, y'all. Master and servant. Boy, I gotta read this case here. I gotta read this. Y'all, they're basing this off principles, y'all. This is principles. All of them. Is for facts and findings, conclusions of law. No, I've never done one of those, Jr. I can, but I've never done one. Peonage at its finest. Let's go, right here. All right, Kerwin versus Wright. Let's see what this case is talking about. All right, I gotta read this. I gotta read this. Master and servant. Articles of indenture by mother. Action by mother for child services. Pleadings. Where a mother binds her minor child to another as an apprentice by articles of indenture providing that the master shall render a specific compensation to the child for its services, she thereby relinquishes all right to compensation for such services, and though such indenture be so informally executed as not to bind the child, in answer by the master to an action against him by the mother for the value of such services, setting up such indenture and alleging performance of its terms is sufficient. Wow. I gotta read this, man. It looks like this is from the same judge from the other case, if I'm not mistaken. This was an action by the appealee against the appellant to recover compensation for work and labor performed by the minor son of the plaintiff for the defendant from December 30th, 1864 to July 30th, 1876. Good God, that's a long time. Like that's over 10 years. The defendant answered first by general denial and second in substance that the work sued for was done under a special contract between the plaintiff and defendant in writing, a copy of which is set out averring that the defendant had performed and was ready to perform the agreement on his part, but the plaintiff and her said son have failed to perform on their part. Okay, so we talking about equity here. It's about a contract. We talking about equity. The written agreement is as follows. This indenture witnesseth that Letty Myers of the county of Grant and the state of Indiana do hereby bind by these presents, doth put and bind out my son John E. Myers to William Kerwin of Grant County to serve him as a former born from the day and date hereof until he is 21 years of age, which will be in the year 1878. So was that 19 was it 1 year 1800, so that's 1878. Okay, at which time he will be 21 years of age if living, during all of which time that said John E. Myers shall well and faithfully serve the said William Kerwin, and that all time. I can't even read this, y'all. Who would make their kid do something? Man, let me go back to the chat. This is a little disturbing, y'all. This is just a little disturbing to me. I'm gonna read it, but this is a little. I'm not really used to reading stuff like this. All right. What is it? John E. Myers shall well and faithfully serve the said William Kerwin, and at all times readily obey the lawful commands of said William Kerwin, and that said William Kerwin doth agree to send that said John E. Myers to school until he is 16 years old, that is 3 months out of the year, and give him all the necessaries of life, such as wearing apparel, a stave. Okay, I see why she did it now. It seems like she couldn't take care of him or something like that. And so, in exchange for his services and labor, he's going to be taking care of the kid. Okay. Well, I mean, I see why they're saying she might have forfeited her rights now. Okay. 16 years old. That is 3 months out of the year, and give him all the necessaries of life. That's a legal term too, by the way, such as wearing apparel, eatables, and to teach him morality and instruct him in the art of farming, and set him off with a suitable suit of clothing and a horse, bridle and saddle worth $100, in testimony whereof, etc. Okay. The instrument was duly signed. When they say instrument, they're talking about this contract. This is equity. Um, I'm not. I don't think this is a negotiable instrument in the sense that it's a money order, a check, or a promissory note or something like that. But it is an instrument. This instrument was duly signed and sealed by Miss Myers, now, as we suppose, Miss Wright, and Kerwin, and attested by witnesses. Okay, so they have witnesses. A demur to the second paragraph of the answer for want of sufficient facts was sustained and the defendant accepted. So it's the same as the other case I just read. Such further proceedings were had as that final judgment was rendered for the plaintiff for $400. The appellant has assigned as errors the sustaining of the demur to the second paragraph in his answer. It does not appear from the pleading that the father of John E. Myers was dead when the contract was entered into and the action brought. But for the purposes of the case, we will assume that he was, as that is the most favorable view of the appellee. Okay. If the plaintiff, as the mother of John E. Myers, has father, let me see. If the plaintiff, as the mother of John E. Myers, his father being dead, was not liable for his support and not entitled to his services while he remained an infant, she cannot maintain an action for the value of the labor performed by him for the defendant, and of course, there was no foundation for the action. If the father was so the mother does not, she doesn't retain the right. It must be the father back then who retained the right to the custody and services of the child. This would make sense at why they intentionally omitted this from it being known, because they couldn't take away the father from the kid and make him liable for the support at the same time if they took the kid from the father and he was not the cause of the custody being deprived from him. If that makes sense, this makes perfect sense to me. Why they intentionally omitted this particular fundamental right in regards to parental rights. That makes perfect sense to me. I actually think that's I actually think that's the reason why they did that. All right, let's get back to it. I got to read that again, y'all. I got to read that again. If the plaintiff, as the mother of John E. Myers, his father being dead, was not liable for his support and not entitled to his services while he remained an infant, she cannot maintain an action for the value of the labor performed by him for the defendant. And of course, there was no foundation for the action. I'm going to have to read that again on my own time. Upon this point, the authorities are not entirely uniform, and we cite such as we have examined for future convenience. What is this? In Reeve Dom Real 3rd edition, page 431, note, it is said, the mother, after the father's death, has no right. Oh, wow. I see exactly why they did that now. If what they're saying is true, I see exactly why they did that now. The mother, after the father's death, has no right to the services of their minor child, nor is she liable as to the father is liable for the support of the as I can't even get the words out. As the father is liable for the support of such child. I see exactly why this makes so much sense to me. Why did they hid this now? Because the mother is not, this is what they're talking about right here. The mother, after the father's death, has no right, and we're not assuming that the father is that this is a father who's alive. All right. So this scenario applies whether the father is alive or he's deceased, is what I'm trying to get y'all to understand. If the father is alive, the mother has no right to the services of the minor child as the father for the support of the child. All right. That now I read that as if the father was alive. Now I'm gonna read it. It's just what it says. The mother, after the father's death, has no right to the services of their minor child, nor is she liable as to the father is liable for the support of the child. So it's not her responsibility to go out and make money and support the kid. It's the father's responsibility. Does that make sense to y'all? Why they hid this due process right from you? That's a property right because the father, this is property, and the mother, that back then, how they're construing the cases, the mother she isn't entitled to the services of the minor child, nor is she liable for the support of the child. Does that make sense? So since she's not entitled to the services and she's not responsible for the support, she has no property interest into the services of the child. So there's no due process issue with that in regards to the mother, but there is for the father. And that is why they hid this. This makes so much sense to me now. This is my first time reading this case, but this makes so much sense to me now. This makes so much sense to me now. Once they are 7 and you haven't claimed them as your property and not abandoned or salvages. Let me get back to reading this case. I got to highlight this. I'm finna highlight, I'm gonna make sure that I remember this case and the one I just cited. Look at this. The following cases are cited which seem to sustain the note. What note are we talking about? This right here. This right here. What I just read. That's what we talking about right there. So this is in, I want to say that this looks like Maine. I'm not sure what these other cases are because a long time ago, they were, even though these were so-called states, these are different. So I have to go and look, but I believe these case citations are on here. I think this is Maine right here. EB versus EDC. I don't know what that is. Barb. I don't know what that is. But these are cases that happen. If I'm not mistaken, I believe they happen in this country, and I'm gonna find out. The last case cited was an action by a mother, the father being dead, for the seduction of her daughter, and it was held that the action would not lie. The court held that the mother was not bound to the duty of maintenance and not entitled to the correlative right of services. Wow. Ha. That's why they omitted that, man. That's why they don't talk about it in this case right here. Because they were talking about this case. This is from the 1800s. They were talking about that case right here. Let me go and show you what I'm talking about. Troxer versus Granville right here. Let's go to case text. Uh, fundamental right to care, custody, control, what is it? Care, custody, control, rear, something like that. I think that's it too. Let me see. But they intentionally leave that last one out because the mother does not have that right, and so they stripped the father of custody and they hid it. Man, these folks so slick. Let me show y'all what I'm talking about. Right here, our courts have recognized a parent's fundamental right to the care, custody, and control of their child. Notice that they leave out the right to the services and labor of the child. They don't talk about that. They just leave it out. They leave it out. A parent's right to the control and custody of her children is a fundamental civil right. The right to custody and control of one's own child is a fundamental right. So on and so forth. At the outset, the court recognized the fundamental right of parents to direct and govern the care, custody, and control of their children. Yeah, but you left out one. You left out one. Man, 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 man. If you don't challenge, why does she need to go outside to seek payment? Did she not ask for custody? If that woman leaves you, or if she gets mad and just go down to one of these administrative agencies and put you on child support, um, she has in essentially she has accepted the duty, like they just said in that other case. She has accepted the duty to maintain the care, custody, and so on and so forth of the kid. That's what she did because the father did not. If he didn't consent to it, and he's not refusing to maintain he's not refusing to perform his duties as the father. She's the let me see. So the offspring is born the biological father's property. Um, it would seem that way. How they have how it seems to be talking about it back in the day. Yeah, because let me go back. I'm gonna go back and read this again because they're saying that the mother is not entitled to that right to the services because because she doesn't have a duty to protect the child. Not protect the child because she doesn't have a duty to provide for the necessaries of the child, meaning the care, um, educating the kid, making sure he's well fed, raising the child up, stuff like that. So how does the mother automatically get custody? All right, let me tell you how. One AC, you need to understand that these are not courts. All right, they look like courts and they function like courts, but they are not courts. They are administrative agencies. They ain't no different than Child Protective Services. They ain't no different than the Department of Motor Vehicles. They ain't no different than the CIA. They are no different than the DOJ. They're no different than the DOT. All right, that's the first thing you need to understand. All right, so what they do, this is what the legislature does. Because what happens is what I'm reading you, these are common law principles, or they are equity principles. They're one of the two. And so what they will do is they will codify these principles from one jurisdiction, meaning equity or common law, and then they will bring this principle over into their jurisdiction, and then they will modify it. That's what they'll do because they have plenary power over there. That's what they're doing. That's exactly what they're doing. And that's a fundamental right too. The father, he has a fundamental right to the services of his kid. Since it's a fundamental right, it's a property issue. You can't be deprived of due process without you can't be deprived of your life, liberty, or property without due process of law. That right to your services and your kid is property because rights are property. They're private property. Let me go back and finish reading that case. All right, I'm gonna start back. The last case cited was an action by a mother, the father being deceased for the seduction of her daughter. I'm guessing something to do with sex or something like that. And it was held that the action would not lie. The court held that the mother was not bound to the duty of maintenance and not entitled to the correlative right to services. They're reciprocal. All right. What is this? In Schulerdom, Rail Second Edition, page 349, it is said, at the common law, a mother had no implied right to the services and earnings of her minor children, not being bound for the child's maintenance. So this has to be based on some sort of natural law principle where the man is the provider or something like that. I think that's what it's relating to. I'm not sure, but I think that's what it's relating to. Nor have her rights or habitabilities in these respects been usually regarded as equivalent to those of a father, even where she is the only surviving parent. But the modern tendency in this country, if not in England, is certainly to treat a mother's rights within considerable favor, especially if she be a widow. And in several late cases, her title has been upheld in her minor child's earnings, so far as concerns third persons, it appearing that she was the surviving parent and that the child had no probate guardian and was not emancipated. Whether such title on her part could be so well enforced against the child's own consent and to the extent of depriving the child of the fruits of his own toil may be reasonably doubted. The following cases support the theory that the mother, the father being deceased, is under some circumstances entitled to the services of her minor children. Now I agree with this. The father is deceased. She's taking care of the kid by default. I think, in my opinion, that is the equitable thing to do. But here's the cases right here. This is in Connecticut. This is in New Hampshire. This is Illinois. This is the third edition in Illinois. So that means that this is an even older case. I'm not third edition, the 13th edition. So this is an older case where this principle was recognized. So I'm gonna go back and I'm gonna look at that case too. And then there's another one. Assuming without deciding that the plaintiff would otherwise have been entitled to recover for the services of her child, we think it clear that she has precluded herself from such right by the contract Ooh. Let me explain this to y'all. And he's absolutely right. The reason why he's saying that is because the contract that she got with this guy who she's suing, which is Mr. Kerwin, um she displaced, or she removed herself from that obligation of providing for the kid. She gave him the obligation. And since he now has that obligation, and those that obligation is reciprocal, he now maintains that right, if I'm not mistaken. If that makes sense to y'all. Does that make sense to y'all? Because when I just read that contract, she essentially placed all of those responsibilities in regards to what a father is supposed to do for his son on him. That's what she did. My case is in Connecticut. Okay. The more I learn, the further I feel like I am. All right. Let's see. Let me get. I'm gonna give y'all this case citation because this is, man. What we got? All right. We think it clear that she has precluded herself from such right by the contract entered into between herself and the defendant, her and the defendant. If she had a right to the services of her son, she had a right to make a contract by which he was to serve the defendant. She sure did. Sure did, boy. And that defendant should pay him and not her for the services. This was done. The defendant was to school and clothe and feed the boy in exchange for his labor, teach him farming and morality, and at the end of the services, set him off with a suitable suit of clothing and a horse, a saddle and bridle, and $100 if I'm not mistaken. That was the deal, right? This is a private contract. This is equity. All right. We take it to be clear that if a father had made such a contract, kept kept on the part of the defendant, he could not himself, he could not have himself, let me see, he could not himself have recovered for the services of the child. And I agree with that because he placed that, he removed that burden from him and he contracted it to somebody else. I agree with that. This was held in the case of, look at this, and they got a case on this. This is why y'all got to go and read these old cases. This was held in the case of, what is this? Schneider versus Everingham, Third Dutcher 143, that where a parent contracts for the services of a minor child, the wages to be paid to the child, the right of action to recover the wages is in the child and not in the parent. Wow, because I'm guessing they may have, that must be some form of emancipation or something like that. I'm not really sure. And here's a case right here in Connecticut, right here, that's saying that the sixth volume, Connecticut Supreme Court, page 547, right there. And here's another one. This looks like Vermont right here. This is why y'all got to go and read these old cases, man. Y'all got to go and read these old cases. The agreement was doubtless inoperative as an as an indenture of apprenticeship because not because not executed in the mode prescribed by the statute. Hmm. The agreement was doubtless inoperative. Okay, they're saying it was obviously operative as an indenture of apprenticeship. Let me go and see what they're talking about. Indenture of apprenticeship. Let's see what that means. Indenture apprenticeship. Indenture is defined as a contract binding a person to work for another for a given length of time. Okay. As an apprentice, you are indentured to the training trust. I knew it was some sort of trust. An apprentice signs an agreement binding him or her to the rules and regulations set forth by the training trust. Okay, that makes sense. But I want y'all to see how it doesn't say apprentice contract or trust or whatever you want to call it. It doesn't say it expressly. It says it implicitly because it's implied in the substance of what the contract says. That matters. Where is it at? The agreement was doubtless inoperative as an indenture of apprenticeship because not executed in the mode prescribed by the statute and did not in any manner bind the body, but it was nevertheless a valid agreement as between the plaintiff and the defendant, so far as the plaintiff had any right to contract the services of her son and to authorize the defendant to pay the son for his services. Okay, I agree with that. As the agreement was invalid as an indenture of apprenticeship, the boy was in no way bound by it, and he might sue the defendant for his services. And there's cases right there supporting it. Look at that. Indiana right there. See also Prey versus Ham, blah, blah, blah. This is a cogent reason why the plaintiff should not recover for the defendant, cannot be held liable to both the plaintiff and her son. I agree with that. For these reasons, we think the court erred in sustaining the demur on to the second paragraph of the answer. The judgment below is reversed with cost, and that cost means tax. They're taxing, and the cause remanded for further proceedings in accordance with this opinion. Let me give y'all this case citation. I think it was 369. Yeah, right here. So it's going to be in the 59th volume of Indiana Supreme Court, and it's going to be on page 369. This was a good case. I got to get off here. I've been on here too long already. All right. Hold on. Somebody text me, y'all. All right. I'm just checking my messages right now, y'all. That's why I'm quiet. Okay. I think that'll be it. I've been on here 2 hours already. I was not supposed to be on here no damn 2 hours, but I'm here. All right. Let me give y'all that case citation again. It's volume what? Volume 59, IND 369. Illinois. It's gonna be Illinois Supreme Court. That's the case citation again. That's the volume right there. Man, they got some good cases in these books. I gotta highlight this before I go though. I gotta highlight this before I go and save it. I'm gonna just highlight. Damn it, that ain't it. I'm trying to highlight this stuff so I won't forget it. Erase. There we go. All right. All right. I'm about to get ready to log off here, y'all. I'm not gonna be on here this long. I'm gonna just do this whole case. So I got to find this right here. All right. Good. Good. All right. That's gonna be it, y'all. What is this? Bond, same. A bond taken by an officer in the discharge of his official duty and an action pending in a certain court is not rendered void, blah, 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 blah. I'll read all that stuff later. I don't got time for that right now. All right, I'm about to go ahead and log off, y'all. I'm tired. About to log off. I think y'all should watch this all the way through. This live. This is a pretty good live right here. This is a pretty good case. I'm gonna go ahead and log off. I gotta finish cleaning up around the house. That'll be the end of this live. Before I go, I gotta promote this again before I log off. If you haven't already, please go ahead and join my membership. Get one of these, your membership, whatever one you want, I don't care. And support the channel. 99 cents a month, I really appreciate it. Or send me a cash app, whatever, for my time if you want. Also, if you need help with drafting documents, then you need to register for draft class. You can read this post right here. It's on my community section of my YouTube channel. You have time. It's $200. It's going to be a 6-day, 18-hour course. All right. The deadline to make the final payment is May the 18th, 2024 at 11:59 p.m. So if you need help with drafting documents, either you can watch videos on my YouTube channel or you can come and register for draft class. All right, read this link right here and it'll give you all the details. If I'm missing anything, just contact me and I'll tell you everything that I can. I'm gonna go ahead and get out of here. That will be it. The Supreme Litigant is out. Peace, y'all. Let's get up out of here.